Good morning. It is September 26th, and this is the Colorado Carbon and Energy Management Commission. We are going to take a roll call.
Thank you, Commissioner Ackerman.
Here.
Commissioner Cross.
Here.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Shea.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 commissioners present.
Great. And 6 is a quorum. We exist for the purposes of doing business in the state of Colorado today. We will continue in our work on docket 240600145. That is the cumulative impacts and enhanced systems and practices rulemaking. AAG Davenport, I might acknowledge you to get us kicked off here this morning.
Thank you, Chair. I think probably the appropriate thing is to maybe to review the spreadsheet that Ms. Trask put together last night to see if there's any additional changes that need to be made so that we can get that out to the world at large, and then move into the consensus / areas where we haven't reached consensus yet document. And with the commission's permission, I'll put up that spreadsheet from last night so that we can make live edits to that.
Go for it.
All right, one moment, please. Can everyone see that? That should look familiar. It's the spreadsheet from yesterday with some edits. We took out the sort of suggestions and just now leave in the current state and the consensus, so everyone can see the comparison between the current version in the rules and what the commission reached as consensus yesterday.
Yeah, we can see it. Good. Thanks.
Is it big enough? Okay.
It is for my tired eyes. Works. Where do we want to start our discussion?
If I can make a suggestion, Chair, if the
Please do.
if any commissioner has changes or edits to this document, it's entirely possible we made some errors and last night, but any corrections, changes, now would be the time, please.
Commissioner Cross.
Thank you, Mr. Chair. And one thing that I wanted to note was in the deliberations about Rule 304, I had also brought up that currently there's a lesser impact area exemption. And I had talked about applying the lesser impact area exemption to RBUs regardless of DI communities within 2,000 feet and expanding it for DI communities. And so I would just propose the addition of the lesser impact area being noted in here as well for the half mile and 4,000 feet for consistency for the lesser impact area exemption requests.
Apologies, my computer is so I'm adding a new tab there, or a new row there. I'm going to put none in to indicate not currently. And then Commissioner Cross, would you state that again so I can type it in, please? You're on mute, Commissioner.
Apologies. Currently, the way the rule reads is that there's 2,000 feet within DI communities for the lesser area exemption request. I propose, for consistency's sake, first of all, that should apply to RBUs, period. I don't think there should be a lesser impact area exemption if you're close to RBUs. And so I think for consistency's sake with what we're doing, having that be a half mile for RBUs not in DIC and 4,000 feet for RBUs in a DIC.
Does
Does
that
that
capture the thought?
correct, Commissioner
Cross?
Cross?
Yes.
Okay, then do we have consensus on this or any issues with other commissioners?
I would support that.
Other commissioners? Thumbs ups.
Okay, if it's okay with the commission, I'd like to make sure that staff and its council understand that as
Yeah.
well.
Ms. Trask?
Good morning, Commissioners. Yes, I agree with this. I think it's the right place.
Great.
Other suggestions, Commissioner Messner?
Thanks. So I don't know if I have an a question, but I would be interested in a conversation. And this has to do with and maybe an explanation for the 304C19 community outreach plan required piece. And so, well, hang on a second. So I've got myself a little bit confused here, and so maybe someone can help me with this. And so we've got information requirements for the community outreach plan, and we've got that at a half mile and a mile. And then, Kyle, if you can move up just a little bit to the 309C, sorry, down 309C post completeness community meeting. And so I can't remember where we landed on the post completeness community meeting for 3019C, or if we're just acknowledging that that would be required only in circumstances when a community outreach plan was required. Does that make sense what I'm saying? Because there is a section in 309C that currently in the August draft rules that talks about this post completeness community meeting and the requirements associated with it. But then there's also sections in 304C19, which are the requirements for the community outreach plan. And so in this table, we've determined that the requirements for a community outreach plan will be the half mile outside, the 1 mile inside. And are we assuming that that then by default would require a post completeness community meeting when a community outreach plan was required? Or so maybe someone can help with that.
Commissioner, if I may, staff didn't intend for there to be some sort of connectivity between the post completeness community meeting and the requirement for the community outreach plan. They do have the same trigger. Well, I guess they don't. The trigger for the meeting is that if there is any RBU within 2,000 feet, the meeting would be held. The notice for that meeting would then go out to a half mile or 4,000 feet, depending on the DI status of the RBUs. The community outreach plan would not be required as an attachment to the 2A if there are no RBUs within a half mile or no DIC RBUs within a mile. So if there are any RBUs within a half mile of the location, then the plan has to be attached to the Form 2A. If there are any DIC RBUs within a mile, that plan would be required. I'm not sure if that was helpful.
I was just trying to figure out how those two things talk to one another. And so 304C19 community outreach plan is still triggered by the requirement for that is still triggered by an RBU inside 2,000 feet. Correct?
That's the current state.
Okay.
Yeah, we're
And so
proposing.
now we're proposing though that the community outreach plan trigger, the requirement for submittal of a community outreach plan would be for RBUs within a half mile or RBUs within a mile. And so I'm good. I understand that. And so then this post-completeness community meeting, which does not seem to have a consensus on it right now. So I guess I'm unsure of the triggers of that and whether that should kind of comport with 304C19's triggers or not.
I would defer to the commission on direction with that.
Well, this is the question that I have for the commission. And so that it seems like those two things should be for just, I'm trying to think about how an operator would apply this. That makes sense to me for those two things to have the same triggers. So I guess that's how I was thinking about it, and just making sure that those two rules talk to one another and comported with one another.
Oops, I'm muted. Commissioner Ackerman?
Thanks, Mr. Chair. And the way I recall this conversation going, Commissioner Messner, is that we did talk about leaving that trigger the same. And we had a little bit of discussion about would that notice then go out to those within the 2,000 feet? And I recall us talking about, well, you know, those are the plans that we generally tend to get the most input on if we have development within 2,000 feet. And so I recall this landing on leaving that trigger at 2,000 feet, but then sending out notice to the same distances required under the community meeting. And others can correct me if they have different recollections.
For me, now that I do now remember that conversation. So thank you for refreshing my memory on that one. And so I guess I'm okay either way, because the notice piece ends up being the most important piece in that. I see some symmetry with having the same triggers as the community outreach plan, although I do acknowledge that some community outreach plans may or may not contemplate a community meeting, but it seems like almost always they do. So it seems like there may be some symmetry with just having those two things have the same trigger. But I do think that the notice piece, you know, accomplishes a lot of the same, and that it would be illogical for me for a community outreach plan to not include a community meeting. So I don't know. That's kind of where my brain is going.
So are we good leaving as is? Believe. Other thoughts on this document? All right, seeing none, I believe we're going to move to a second document prepared by our attorney generals. The sort of things that we've reached consensus to, and a couple of items that we have not. Does that sound accurate, AG Davenport?
That was my suggestion. I want to note for the public and commissioners, reaching consensus on anything here today or previously is not a final decision. That there will not be a final decision until the 8th or the 15th, whenever we get to that point. So while the consensus here today will direct staff's revisions to the draft rules for final consideration, I just want to be very clear with everyone that the commission is not making a final decision on anything today. Is that?
Yeah, that's fair. These are straw votes. These are trying to get to a place where we're making progress. Nobody is bound to anything. We're just moving iteratively through the process with these sort of thoughts on places that folks get comfortable.
Yeah, and just also, if I may, to be clear, it's important, obviously, because staff will revise the rules based on the direction here today, but just making the distinction between that and this not being a final decision. Okay. Give me one moment while I bring up the other document. And is it the commission's pleasure to get to the topics that I indicated I didn't see consensus yet on first, or to get to the topics where I thought we had consensus first? What would everyone like to do?
Go ahead, Commissioner Ackerman.
I'm sorry, I didn't mean to preempt you, Mr. Chair. I would
No, go
just
ahead.
suggest we hit consensus items first. I think there's a chance we can move through that relatively quickly, and the other will probably require some discussion.
I was going to say the same thing. Let's get some early 9/18 wins.
Sounds good. One moment, please. You should all be seeing screen share now. Is that big enough for everyone?
Yeah, it looks good.
Okay, so this is where I thought we had consensus. There, you will see some red or blue lines in this document. Commissioner Oath sent me some thoughts last night on some things, which I then put in red line. So please see the red lines as where we probably, I think we still have consensus, but be aware that those are different than the document. Those are changes to the document I sent to you last night. I attempted to somewhat put these, reorder these from your deliberations into an order that they appear in the rules. So definitions come up first, and then numerically through the rest of the rule series. It's not perfect, but I made that attempt.
No, and I just want to express appreciations for that. That's extra work over and beyond the calls of duty, and it really makes it more helpful for us. So thank you very much, AAG Davenport, for the continued excellent attorney support here.
Sure. Thank you, Chair. If I can make a suggestion, please let me know. This is the beginning of that with the definitions. And I'm happy to scroll down or as we get through things, but if anybody has issues with anything that I've said here, again, this isn't intended to be rule language. It's concepts unless indicated otherwise. Staff will incorporate these into actual rule language or SBP as well.
Commissioner Ackerman?
Thank you. And that was going to be my procedural question. I certainly have some statement of basis and purpose comments. I had kind of amalgamated all that into one comment section kind of at the end of the meeting, just for reiteration purposes. It's probably more efficient to do it that way, but if we want to talk about basis and purpose inclusions as we go through these, I'm happy to do that as well.
I think if folks want to editorialize with SBP thoughts, it might be a good time to try to capture some of that. And then AAG Davenport can capture it in parens or something like that, so that our staff is given full direction on which way to go between now and the time we reconvene on the 8th. Does that make sense, Commissioner Ackerman? Is that
Sure does.
cohort
Thank you,
with what
Chair.
you were thinking?
That'd be just fine. Thank you.
Do you want to opine on biological resources at all?
Yeah, I'll just be really quick on this one, and I don't have any edits to what Councilor Davenport has included here. I just wanted to suggest some direction in the statement of basis and purpose, also to ensure that staff is working with Colorado Parks and Wildlife. I don't know that in this case we need to necessarily run those regulations by them when we redline the regulations, as they're pretty straightforward, but I do think it would be helpful to have them take a look at the statement of basis and purpose and offer some suggestions that would correspond with some of the discussion that we've had.
Thanks, Commissioner. So as I understand it, that's direction of staff to run the statement of basis and purpose for this rulemaking by CPW, not language you want to actually go into the statement of basis and purpose.
Okay. Yeah, exactly. Thank you.
Okay. My intent here is to put down in this document changes to be made actually to the statement of basis and purpose, which is why I deleted that.
That's
But
great.
we've got Ms. Trask and AAG's Stafford and Mercer who hopefully heard that as well. So direction received.
Thank you.
Right. Everyone's taking notes. Do you want to scroll down then?
Okay, nothing on DI definition. Industrial facility definition, these blue lines / red lines reflect what Commissioner Oath sent me, and I with some better language, which I think reflects Commissioner Shea's suggested language. It's not a substantive change in my view. It's more of a different way to state the same thing.
Yep. Thank you, Commissioner Oath. Thank you, Commissioner Shea. I'm good with that.
Okay.
Reasonably foreseeable future development. No change. Impact area. Roll it down to that. Move it to area of evaluation.
Oh, one thing here. If I may, Mr. Chair. AAG
Yes.
Getforth, thanks for adding that in. However, it is an and in between this exception. So outside of the non-attainment area and operator demonstrates topographic relief.
Thank you.
Thank you.
So I have a question about this one. And it goes to, I think, the conversation about the pre-application process. But again, by saying that the director may expand the area of evaluation, that puts again the burden of proof on the director versus that, you know, an operator may propose to expand, which I think continues to maintain the burden of proof on the operator, and I think falls into at least what I believe we have some consensus around as far as a pre-application process.
I agree. Good catch. So it could just
So
be
something like following a request by operator, comma.
or AOE can be expanded but not contracted.
Well, I would remove the reference to the director totally, because this is the operator making a determination of whether they're going to follow the default impact areas associated with the rules or propose a different impact area. So, you know, applicant may expand, may propose to expand, I guess. So, I mean, I think that generally captures at least intent. It may have to be massaged a little bit as the rule actually, or the definition gets developed, but my intent, at least in making a comment here, is to make sure that the burden of proof is maintained on the operator and not placed on the director.
And I think you change unless to based upon or instead of unless the proposed, but where the operation is outside of the non-attainment and the operator demonstrates typical relief is present or something like that.
What if I said, but here, try. Come on, computer.
And I think the point here is try to capture the commission's consensus, but not try to finally draft all this. And then we'll leave it to the AAGs and staff to actually draft good language. Because if we're trying to draft everything today, we're not going to be here until midnight.
We good there? That's not the end of area evaluation, just the end of this particular.
Yeah, I think so.
Mr.
Move
Chair, I don't
down.
know if you can see, but I've got my hand up there.
Oh, sorry about that, Commissioner Ackerman. Didn't
That's
see you.
okay. I know when we expand our screen, it's difficult to see, so thank you. I apologize for jumping in. I agree with the chair's thoughts on not drafting everything here. I do think that if you can go back to that language, Counselor, I don't want to raise some kind of a concern that those are the two criteria that have to be met in order to contract an area. So if you can take that into account as you continue to draft this, that last clause may lead one to believe that those two criteria are met, it can be contracted.
Okay. I'm gonna suggest perhaps proposed to indicating final decision is still always with the commission.
Again, I'll leave it to you, but I would just want to make sure that we make clear that there are other criteria that must be met.
That sounds good.
I'm sorry, my computer is being really slow right now. All right, so this is continuing on with the area of evaluation.
So for me, that first line would just get struck. Because again, that's, well, all right, let me restate that. I acknowledge that even in the pre-application process or through even the technical review process, that agencies with expertise certainly can provide input to the operator on, appropriateness of an expanded area of evaluation. But I want to again make sure that there's not a decision being made, in a pre-application process, but rather information is being provided and even opinion being provided, but that the burden maintains with the operator if they're intending to contemplate an expanded area of, or contracted area of evaluation, in that process. And so I read this, and maybe I'm misreading it, but I read this as saying that if the state agency gives it a thumbs up or makes a decision in a pre-application process that it's okay, then it's okay through the process. Does that make sense?
Yeah, and I might chime in there too, Commissioner Messner, because I think this concept kind of came from me, and deference might not be the right word there. And I agree with your philosophical comments there. Really, what I was trying to get at here is I want to make clear that it's not the commission's, or at least my intent, that this would begin some kind of a long negotiative process, and that the recommendation of that agency might hold some sway as the operator continues to think about how to approach the project, rather than that being the beginning of a negotiation with that agency itself.
This is not great language.
Yeah, I think just some caveat like that in the SBP should address the concern that continues to be vocalized by Commissioner Messner. And that way we're not going to have to go back and kind of like restate this point every time for every one of the definitional pieces. Commissioner Messner, does that accommodate the concern that you've raised a couple times this morning?
I mean, it does. I just want to also make sure that the rule language itself doesn't infer it, by words like deference, right? And so, and I think this really only applies as we're talking with areas of evaluation and this concept generally, but I do think some consideration in the statement of basis and purpose is warranted as well, should there be any questions about this concept.
Perhaps as staff is going through the drafting process, could we leave it to staff's discretion, at least till commission final review, as to whether or not it's appropriate to be an SBP statement or perhaps rule language?
Yeah, I think so.
Okay.
Anything on the next couple of paragraphs, folks?
Commissioner Messner, just, I think that no changes to process in August draft was like not about not changing the things that you you noted for pre-application process, more like that in the deliberations I had initially talked about a different process that we decided not to go with. So I think it was just capturing that.
Did I delete this highlighted language?
Probably, yeah.
Yeah.
We'll see how it goes. My computer is being so slow. I may have to send this to another scribe so everyone's not watching my computer have some kind of weird issue, but it's moving so far. Community liaison.
I mean,
Okay.
clearly, I think we're still looking for some clarification on the bolded parenthetical there, right? And as per the discussion, I do think it's good to move towards a summary of feedback rather than some kind of a interpretation of opinions. I think to me the intent would be essentially passing on the information that was provided rather than trying to distill that into some kind of an opinion.
Yeah, and I think on that one, and if you give me a second here, I'll look. I thought I had suggested some language. Give me a second.
While commissioners are looking, something just popped into my head on general process. Is it acceptable to the commission if staff or its counsel jumps in to either ask for clarification or provide some feedback on any of this consensus?
Yes.
Okay.
So Ms. Trask and or council for you to visualize and be a part of the discussion.
So the language that I had put in here, and I think I might be confused some people because I didn't strike through that section 11, but I had put to provide a written consultation to the director, and maybe it's captured. Hang on a second. To be included a review of the applicant's efforts to engage DIC members and the positions of the DIC members regarding the oil and gas development proposed in the OGP application. So I do actually think that that language is captured with the intent that it is a review of the applicant's efforts. Like they're looking at the summary provided by the applicant and reviewing it and having it as part of a consultation process. And I do think that, as Commissioner Ackerman indicated, that the question is whether positions is the right word. And I would agree that that may not be the right word because that would indicate either they're for it or against it. And so I think the perspectives language would be appropriate in lieu of the positions. But if there is better language that would capture the intent of not making the community liaison be the primary scribe of the summary of the applicant's efforts to engage DIC members, but rather a review of the applicant's summary of their efforts to engage in DIC members. That at least was my intent, whether I captured that in the language or not.
So are we then considering changing the word positions to perspectives and calling it good?
I support that.
And honestly, this is a little hard for me because I don't have the draft that we were looking at. And I only have this, like, I don't have C11 in front of me. And then C10, I don't have that in front of me either. So I find this a little bit difficult to try to on the fly figure out. Because this was something that I think you put on the screen at a point during discussions, and I don't have it in front of me again. I don't know, do y'all have it in front of you?
You have it in your inbox, and it's also in the portfolio under Commissioner Redlines.
Well, it'd be easier if we actually raised the actual thing up for us to look at. I'm not going to be able to navigate back and forth between portfolio and red lines and this, that, and the other.
Should I stop screen sharing for a minute and find the other one? And find the red line?
I'm okay with this because I know what we're talking about, but like, I don't know what strike the second sentence in C10 means.
It was, Commissioner, or Chair Robbins, excuse me, this was about, the exact sentence says, this may include assisting community members as necessary to organize a community benefit group. And I think we felt like we didn't know what all that was going to
Okay.
entail, and so we felt we wanted to strike it.
No, I appreciate that.
Sure.
That makes sense. And now
Yeah.
I'm comfortable, but otherwise I would not have known what that meant. So
The
So to go back to your
perspectives,
original question, Chair, I would support changing to perspectives and then being good with the rest.
I note that AG Stafford showed up. Is this, do we need to go back? AG Stafford, are we, okay, sorry. Are we done with community liaison?
I think so.
All right. Mr. Chair, may I turn to AG Stafford and see if we need to go backwards in this document or up?
Sure.
Thanks, AAG Davenport. I was trying to be patient here and not interrupt the workflow. But if we could go back to this area of evaluation, impact area discussion. I think Ms. Trask specifically, I think we have a couple of questions about the particular process that's being proposed, and a concern that this might actually be more burdensome on staff in the long run. And so I would ask that we recognize Ms. Trask to just kind of explain her concerns there.
Ms. Trask?
Thank you, Commissioner. Thank you, AAG Stafford and Chair Robbins. I truly appreciate, Commissioner Messner, your desire to try to lessen the burden on staff and place the burden where I believe it should be, is on the operator. I'm in alignment with you on that. I have some concern that the process as laid out here, where the operator is determining the area of evaluation, would somewhat hobble staff. My understanding is that staff could make a recommendation, the director could make a recommendation at the pre-application meeting, a recommendation to the operator that says, we believe you should expand the area of evaluation out to X point to include this thing that's out there. And but the operator wouldn't have to follow that recommendation. And so then once the application is submitted and staff is doing full technical review, if staff again felt that there was a need to include something beyond the area of evaluation, staff doesn't have any authority to require that expansion. And there are instances during technical review where staff is negotiating with an operator, and there are times when staff will ask for something and the operator will say that's not required by rule. I have some fear that this might be one of those things where staff asks for the expansion and the operator says, I don't have to expand that, that's not required by rule. And so then it places a burden on staff to work around that, to try to understand the cumulative impact analysis minus the thing out here that we want information on, and puts us in an awkward situation where we're writing a director's recommendation that says staff requested an expansion of this and the operator said no. I think that puts staff in a bit of an adversarial position potentially with an applicant. And that's not the relationship that we want to have with applicants in general. So I just wanted to flag that I'm not sure this is quite at the right place yet.
Commissioner Messner?
Thank you, Ms. Trask. So I guess respectfully, I'll disagree with you. I actually think that this is a standard process that we're already doing with alternative location analysis and variances, where there is nothing in the rules that would allow for staff to require different alternative location analysis, but rather suggest different alternative location analysis based on your expertise. And the operator is at their own risk choosing to take your recommendation or not. And the process is designed so that if an operator, which would be illogical for me, for an operator to not take the recommendation of staff, whether that's for an area of evaluation or whether that's for an alternative location analysis, or whether that is staff's opinion, whether a variance that's requested as part of a OGDP application is appropriate or not. And should they want to go through that whole process and have the director's recommendation indicate that, you know, you provided feedback that this was not an appropriate area of evaluation, whether that's well, I would assume that would only be in a situation where there's a contraction, then they would get in front of the commission. The commission would have a director's recommendation indicating that staff didn't believe that there were certain elements that were incorporated in the application that were necessary for them to make a determination. I would assume at that point, if the information that was not available or wasn't provided that was necessary for the director or staff to make a determination, that would result in, you know, a recommendation for denial. At this point, then the commission would make a determination as to how to apply that. But you know, my experience would tell me that more often than not, the staff or the commission agrees with the director's recommendation. And so that risk, that burden is maintained on the applicant throughout the process. And so, and again, you know, based on my earlier conversations about the area of evaluation, I think it's important that we develop our default areas of evaluation at the appropriate scale so that that becomes, you know, the most logical utilization of the area of impact in an application process. If it is something different than the area of evaluation, I would assume that that would be an exceptional circumstance, and that would get discussed, and staff would provide their thoughts on that in the pre-application meeting, as well as throughout the completeness determination and the technical review process. And if the applicant makes a decision that they want to do something different against staff's recommendations, that's at their own risk, and they're going to have to go through that process. And so I find that similar to land use processes, whether an applicant agrees whether something conforms to a particular plan, and staff could certainly make a recommendation that they don't believe that it conforms with a certain plan and that there should be some modifications to the application in order to have it conform to a certain plan. But there are some times when an applicant decides to continue that through the process, you know, against staff's recommendation. And at that point, the staff makes a recommendation of denial or puts conditions of approval on their recommendation, and it comes to the commission for determination. So to me, this is a very standard process, and you know, maintains the burden of proof on the operator, still provides staff the ability to utilize their expertise to influence any changes that an operator may want to see an operator implement. And then whether the operator chooses to implement that feedback from staff or not places the risk and the burden on the operator where it belongs.
Okay, so let me wonder here. I mean, Ms. Trask, can't we accommodate the concern you raised by putting within either the rule or the SBP that the director may recommend that the area of evaluation is expanded on a case-by-case basis? Does that give you enough authority to make a recommendation?
I think so. I just want to make sure that staff is not having to argue.
Exactly. And I
Yeah.
want to give you that
Yeah.
authority, and you guys are the subject matter experts. And when the applicant comes in and here's their area of evaluation, if you look at it and you think it's not big enough or whatever, I think staff ought to have the ability to make a suggestion that it needs to be bigger. I don't think that's inconsistent with what Commissioner Messner is suggesting, that the burden remains on the applicant. But I agree. I don't want you guys to not have the ability to adjust the area of evaluation on a case-by-case basis or make a suggestion to adjust it.
Yeah,
Mr. Chair,
sorry. go ahead.
AHE Davenport?
sorry to interrupt. In my view, we've moved into one of the two big areas where I thought we hadn't reached consensus yet. And so I sort of want to, if it's possible, make a decision. Are we moving into this topic? Are we staying with trying to get through the areas where there's consensus?
Oh, I think what we could do, I would like to try to get through areas of consensus before our first break. So why don't we put a pen in this and realize that this is an area of non-consensus that we need to get back to, and have a full discussion about it at that point in time, so that this area it's not finished. We're going to come back to it. Anybody have a problem with that? I don't know, throw it in, make it italics or something, or yeah, highlight. There you go.
But highlighted because it's in the consensus areas, but still subject to discussion.
Yeah, and I want to encourage Ms. Trask and Ms. Stafford to be a party element in these discussions. We make decisions on rules, but you guys got to implement them. And so if in the implementability piece you see concerns, I, at least as one commissioner, want to hear it.
Thank you, Chair. I appreciate it.
All right, local government, consider not defer. I think we're good there. ALA.
And I would note, this is excluding, at least that was my intent, the discussion that I think we still need to have as to how ALA's CIAs work between caps and OGDPs. That was the other main topic that I think that I wasn't sure the commission had reached consensus on. So
Yeah, so do you want to highlight this one as well, AG Davenport?
in my view, these two weren't related, but if we want to try to do kind of all ALA Rule 304 together, that's fine. I just realized I think we've already made this decision, so I'm going to delete this because I think it appears in the table we just went through.
Yeah, I had that in my notes as well. How about the one right below it as well, the lesser impact area exemption?
Okay.
And those were two of my notes, and then the other note I was going to have is I did send Ms. Truss the language that I mentioned in the hearing. So I don't know if we want to bring that up or just address it as we actually get the new draft.
Is there a lot of language? Is that something we can just read into the record now?
Yeah, I'm happy to read it into the record again. So, and maybe it makes sense for me to reread what was proposed before or what exists. Let me pull up the existing rules here to make sure I have the right part. So 304B. So 304B information requirements currently states all Form 2As will include the following information unless otherwise provided in a commission order approving a cap pursuant to Rule 314. And so my idea with that was, and this was based off of conversations with allied local governments, that the language was a little messy, a little ambiguous, and I thought it better to refer specifically to the rule, or to the rule in 314 below. So my proposed language was all Form 2As will include the following information except as provided in Rule 314B for certain Form 2As associated with approved caps. So instead of referring to the order, just referring to 314B.
Commissioner Cross, would you, I'm sorry, read that again and maybe a little bit slightly slower?
Sure. All Form 2As will include the following information except as provided in Rule 314B for certain Form 2As associated with approved caps.
Okay, got it.
And again, for record purposes, that was with discussions with allied local governments.
And just so I'm clear, I don't have a problem with that. But is the discussion here that we're going to have further discussion on other rules associated with 304 ALAs, including perhaps information requirements and other criteria later on? Or I guess I heard some conversation about putting a pin in this and talking about 304 as a whole later. So I'm not sure what we're doing.
Mr. Chair, may I clarify at least my intent in regard to this document?
Absolutely.
Thank you. This section under Rule 304 captured what I believed were Commissioner Cross's suggestions or ideas that I thought the commission reached consensus on. It is another topic is how ALAs, CIAs will be treated in regard to caps and OGDPs. I think really specifically is when there's preliminary siting or when there's not preliminary siting, how do ALAs and CLAs work within caps and OGDPs? So that's sort of a self-contained topic that I did not see the commission had reached consensus on. Outside of that issue where I did not see the commission had reached consensus and everything stated in here under Rule 304, I didn't see consensus or any major discussion on anything else. So at this point, if there are things that need to be added, I think there are two options. Do it now in this document, excluding that sort of self-contained issue of how do ALAs and CIAs work with preliminary siting and caps, or let's wait till we do the walkthrough.
Okay, well, let me throw out a couple of things, and you commissioners, you tell me where they should go and if we should discuss them, and if so, when we should discuss them. But I did in my notes have some suggestions about things that need to be included in the contents of an alternative location analysis, and some of this came from the allied local governments about all proximal existing and permitted oil and gas locations, all disproportionately impacted communities within 2,000 feet of each oil and gas location analyzed in the alternative location analysis, any major transportation corridors, including but not limited to interstate or state highway or railroad within the impact area, And then some discussions about maps for high priority habitats within 2,000 feet of each location. Those are suggestions that they made. I don't recall having a conversation about those, and so I guess I want to identify those as things that I think are worthy of a conversation, or any other inclusions in, the alternative location analysis contents. And then there was also some recommendations, and I think are important in our discussion. We've talked about places to apply language that around the mitigation hierarchy. And I think that from my perspective, allied local governments made some really good points about where and how we explain the mitigation hierarchy and how it applies in the rules, and then how we, and so this is further on in 304. It's not the contents, but rather how we review. And it may not even be in 304, it may be further down, but I do want to have a conversation about like the desegregation of the mitigation hierarchy, and independently going through the avoid, then the minimize, then the mitigate, and how that works. Because I think they had some really good suggestions on how that's applied in local government land use review processes. And I think that that can and should be built into our rules as well, as it relates to alternative location analysis. And so I wanted to get that out there, because like I said yesterday, my time's missing things in my notes. And so now that we're kind of starting to go through this a little more systematically, I want to just highlight those as two things I would like to have discussions on.
I think I'll say certainly the contents of what's talked about in the ALA, I think it's something we should talk about now, given that I don't know that we have discussed it. I will say, at least with respect to some of the notes you just provided there, Commissioner Messner, some of those things are already included in the contents of the alternative location analysis, including the proximal existing and permitted oil and gas locations, disproportionately impacted communities within 2,000 feet, et cetera. So certainly, as I don't think this is something we should talk about in the going step by step, because it hasn't been deliberated on at this point. So I think it would be appropriate to talk about that now. With respect to the disaggregation of the mitigation hierarchy, I know there was some small comments on it, and it was, as Commissioner Messner raised, it was brought up by allied local governments, and I know several other parties were in consensus that that's appropriate. I'm trying to look through my notes now to remember where that is, so I don't know if that's a 304 topic or something else, but I think that's also worth being discussed in this portion, going through this document, as opposed to going through the new draft when it comes out.
Commissioner Oath?
Thank you, Mr. Chair. I agree on the mitigation hierarchy. I think I had also flagged that it'll probably show up later in Kyle and AG Davenport's document, because I had added that as well. If I don't know if you all are comfortable with this, I would be comfortable just kind of indicating to staff that we want to see that shown up in appropriate places, and to bring that back in the draft, and we can and kind of pointing to particular parties' suggestions. I had also flagged, I think, that allied local government and Oxy had provided some suggested red lines in various sections, and so would love to see staff kind of take a look at that and really implement that in the appropriate places, but given the input from various parties.
Mr. Chair,
Yeah, AG Davenport, go ahead.
process suggestion, not a substantive suggestion. We've been identifying things that deserve additional discussion or need additional discussion. Is it possible, or the commission's preference, to continue to get through the things that don't need additional discussion, and then return to the items that do need additional discussion, them being these two, in part, these two topics we've already discussed, or do you want to deal with them now?
And just as one commissioner, I'd rather try to get through the list of things that we've got consensus on, break, and then come back and have discussion around the other items.
That works for me.
Commissioner Messner?
But, and I agree. I appreciate that. And I think as we go through this, it's also kind of jogging my memory on some things. So if we could just have a, you know, a parking lot or a sandbox off to the side where we can say, oh, I remember that we need to have further discussion on that, and then stick it over in the parking lot. I think that would be helpful as we go through this thing that we think we have consensus on.
Let's call it a parking lot. AG Davenport, are you good?
Yeah, whatever the commission would like to do.
All right, then let's keep moving down, and you're creating a parking lot for these other things. Everyone good on 304E? All right, keep moving. Okay, 308, 311 through 12, I think we're good there.
Okay, so the NOx intensity targets is a big target and also includes some red lines that Commissioner Oath sent me last night. Some of these are organizational, including this first red line, in my view, which sort of directs how to draft.
I agree. I just wanted to make sure it was really clear.
Thank you. I appreciate it.
Thanks, Commissioner Oath.
So here, I'll do this.
AG Davenport, I'm not seeing any concerns. AG Stafford.
Thank you, Mr. Chair. I'm popping up mainly because I see the language discussing retaining the controlling interest language, and I understood that I was to do some further research on that based on some of the conversations that occurred a few days ago. And so I just wanted to pop in and discuss what I learned, and at least what staff's perspective is on this piece right now. So the controlling interest language, this refers to the language that is part of, and I'm scrolling through the notes or through the draft rule as quickly as I can. This is 316A1. There are also a couple of provisions elsewhere in the rules that discuss controlling interest. And so essentially, this language was placed in the draft originally as a way to try and capture what Regulation 7 is trying to do for the NOx and GHG intensity targets. And that is to ensure that operators understood that, you know, ECMC wants to understand those targets in the way that CDPHE does. And that means that, you know, according to these targets, compliance is according to CDPHE's Regulation 7, compliance with the NOx intensity target and the GHG intensity target is demonstrated by the parent entity. And understanding that we have a different sort of way of understanding what it means to be an operator under our rules. That means, you know, some operators that could be considered subsidiaries of a larger entity are actually just called an operator under our rules and submit OGDPs and that process. So in my research and talking with some colleagues of mine that represent the Air Division, I came to understand that it's really not as simple as putting a provision in here with respect to controlling, to discuss the controlling interest. There are some intricacies that I'm not sure that we all fully understood until fairly recently, and that pertains to how the targets are reported to CDPHE. And if we simply sort of ask them to be reported in the same way to us, we could be potentially not asking for the same information. So after some discussion with, again, some of my colleagues in the AG's office, I think we landed in a spot where it seems like the best way to go here is to remove the controlling interest language from the draft rules, but then to explain in the SBP that we expect that operators will be reporting the information that we need to understand their compliance with NOx and GHG intensity. We need the same information that indicates they will be in compliance with those targets, meaning that their parent entity is in compliance. So if a subsidiary operator of a larger parent is submitting an OGDP, we need to know the information about the parent's compliance status with the NOx and GHG intensity targets. And it's not as simple as taking some of the language from Regulation 7 and sort of massaging it into the rules in the way that we did, because the different targets talk about parents and subsidiaries in a different way. So that sort of makes this a larger and more complicated issue than I think we had originally anticipated. So it's at least I've discussed this with Ms. Trask. I think we're on board with the suggestion here that, again, we simply take out what we have here and discuss more thoroughly in the SBP what we are looking for from operators for the GHG and NOx intensity targets.
Commissioner Oath?
Thank you, Mr. Chair, and thank you, Ms. Stefford. I really appreciate that and your diligence in following up on this topic. I think in general, that makes a lot of sense, and I'm supportive of that approach. Just one clarifying question. Are you then, is it, I'm trying to find the exact section, but there was like in Occidental's, Oxy's Exhibit 17, they retained the first sentence, but then struck all the controlling interest language. Is that what you're saying, or saying strike the entire paragraph? Just to be clear.
Thanks, Commissioner Oath. So at least from my perspective, I think at this point it's and it's been recommended to me from my colleagues in the AG's office that we simply strike the entire thing, not retain any of that. And that would impact, I think, 3 other rule subsections, not just 316A1. So anything that talks about controlling interest, we should remove, and then discuss more specifically in the SBP what we are expecting of operators for those target reporting.
Okay. Thank you for that. And again, I appreciate you following up on that and support that approach.
Yeah, I appreciate the points made there and appreciate the follow-up for sure. Commissioner Cross?
Thank you, Mr. Chair, and I also want to say my thanks to AAG staff for that's helpful. I want to, if I can, just go back up for one comment on the paragraph above the 316A3B 3BB. Perhaps and this is a small note. I know one of my questions to Commissioner Oath was about the shutting in aspect of it. And obviously this is something that, again, I agree with the director discretion on how to do this, but maybe we have a discussion in the SBP about the shutting in, given that that would change production numbers and thus change the denominator and perhaps increase the intensity. And so maybe we just have something in there that talks about an explanation as to why the approach is being taken. And how, I don't know, something about why the director's proposed action is being taken, and how it will help meet our targets and moving forward.
I'm supportive of that.
Commissioner Oath, go ahead.
Yeah, I'm supportive of that. I think that makes sense. With one caveat that this is adding statement of basis and purpose language, not regulatory language.
Correct.
Correct.
And actually, is that explanation, I'm not sure that explanation is to the operator. I think it's to us.
Yes, correct.
Can I just provide some, I don't know if you'd want to include this, but I imagine, if I can speak.
Yes.
Okay. You'd probably want to be very targeted on if you're going to require shut-in of wells and P&A of wells, you probably want to be targeted with those that have the, the highest emissions and the lowest production so that, you could obviously then be in a position where you're more likely to attain those targets. I don't know if that's something you want to put here or if that's just a given, but something to think about.
Commission Chair, if I may, I appreciate that comment from Commissioner Shea. I would maybe want to think a little bit about how that intersects with the methane emission reduction program, the MERP grant that ECMC is currently developing. I don't know if there's a nexus there, but I would want to give a little bit of thought to that so that we don't overstep in rules or in SBP the direction that we're taking with the federal MERP grant.
AG Davenport.
I would say at this point, we've probably gotten enough to indicate consensus. And if staff needs to think about something, or I think staff still has the ability to come back to the commission later and say, we recognize this was your consensus. We've identified a problem. And here's our proposal as to how to get around that problem.
Okay. I think I agree.
And just, sorry, one more thing. I see this document having two purposes. One, it indicates commissioner consensus, but two, it's also providing direction to staff as to how to revise the rules from the August draft. So
Yeah.
I do think there's ability for staff to take this direction and draft specifically draft specific language to achieve that direction. I don't believe we need to draft language now.
Agree.
I have another question, if I might, Chair. Highlighting indicates parking lot. Is striking all controlling interest language, is that still a parking lot, or do we have consensus on that?
I think we've got consensus. Folks, what are your thoughts?
I'm in favor.
Yeah.
Great.
Okay, it's out. It's no longer parked.
Anything here?
This is all
People?
still under NOx intensity target heading, by the way.
I think you can keep scrolling. Okay. Okay.
This is the end of the consensus portion of this document, by the way.
Okay. All right. With that, maybe we can take a short break and then come back and have chats about areas where we don't have consensus yet. Does that sound fair? All right, let's return at 10:31, 10 minutes. All right, commissioners, we are back on the record in 240600145. It is September 26th and it is 10:31. AAG Davenport, where do you want to lead us next?
Thank you, Chair. Next, we have, in my view, the parking lot, which I think makes sense to me to start with one of two different topics, which is identified in the document I sent last night, which I will share. One is the the matter we've already started to get into a little bit, and that is the pre-application area of evaluation process.
Mhm.
The other main topic, recognizing that there are more than just these two, is how ALAs, CIAs work within CAPs and OGDPs. The first is, I think, is Commissioner Messner assigned topic. The second was Commissioner Cross assigned topic, and wherever the commission would like to go next, I await your direction.
Let's just tackle that first topic first, if you want to share your screen.
This contains my summary of deliberations. I also note that Commissioner Messner did put together a red line, which was shared with you this morning. If it would be better to put that red line up, I can do that as well.
It might be easier just to look at actual rule language than this summary of the issues. So maybe if we bring up the red line, I'm looking to fellow commissioners, we don't have a actual, you got to do it this way, you got to do it that way. Does that sound okay?
I agree. I think it'd be better to look at Commissioner Meissner's red line.
I'll indicate that the red line was not necessarily designed to, comprehensively rewrite the rules, but to try to get into the red line, the intent of the summary that I provided you all when I presented this. I think it does do a relatively good job of like providing the intent that I had hoped to accomplish when I presented this concept, a few days ago. And so I guess I'll just preempt the showing of the red line with that. But I'm not an expert at writing the rules, but
Well, with that disclaimer, let's go ahead and show the red line and let's take a look at it.
I'm working on that right now. I'm trying to get it to a point where, sorry, I need one more minute. I'm a little bit worried about sharing this in an email, so I want to copy paste this into a Word document to avoid any inadvertent information showing or
Oh yeah, I see that.
screen.
All right, let's not, let's take a couple
I'm good,
minutes.
Commissioner. I'm ready to go.
Okay.
Yep. Let me just shut down a few things first. All right. Okay, all I did was paste this into a Word document, so this doesn't appear. Commissioner Messner, I think everything in a color was your addition. Because I copied and pasted from an email, it's not a red line in the way that it normally appears, but I believe anything in a color was something you added.
that's correct. I have my own special color coordination, and so it is true. Any color is probably something that I added. I also didn't always strike through, but so like for this page, for example, this could be included in the above. It could replace the above. It could be stricken through, but the bottom red piece on this is really getting at my intent.
Does it make sense to have Commissioner Messner kind of go through what he was thinking and describe the red lines?
I'm
Sure.
happy to do that.
Okay.
And so if you want to just go up there quick, I can maybe clarify that. So, we did talk about that a pre-application meeting that is held by a local government should and could be used in lieu of ECMC holding a pre-application meeting in every instance. But I wanted to capture that it has to meet the local government process should meet the requirements of Rule 301G, or it can be held by the director if that local government process doesn't include the requirements of 301G. So that's the intent there. So you can go on. Again, this is to capture that so long as it meets the requirements of Rule 301G. And I did utilize the word meeting instead of consultation throughout the rules.
Can
And-
I ask you a question about that, Commissioner Messner?
Yes,
I'm sorry to interrupt, and I absolutely don't want to go word by word and wordsmith here, but to the point you just made, sometimes you've replaced it with meeting and sometimes the word consultation is
If the
still
word-
here.
if the word consultation is still in there, I just missed it.
Okay, good. I just was trying to understand if it was like referring back to that formal consultation or not. Okay, thanks.
And I'm sure I missed some places. So in one here, again, the meeting, the director will participate in one or more pre-application, that should be meetings, with the operator and all persons identified in Rule 301G2. I did strike that it is a formal consultation process because in my mind, it's an informal meeting. The purpose of the pre-application meeting is for the director, operator, and invited participants in Rule 301G2 to engage in high-level discussions regarding various processes, standards, and submittal requirements, and to answer any questions the applicant has about process or the requirements regarding their proposed oil and gas development plan or CAP. And then it goes on to talk about the different things. So I did strike a couple of things in there. I added a couple of things in there. Is there any questions about one? So then again, in A, the oil and gas location siting, including whether the proposed location is within a DIC, has RBUs, HOBUs, school facilities, childcare centers within 2,000 feet of the working bed surface of the location, is within a high priority habitats, or is in proximity to other sensitive receptors. Something just happened.
Apologies, I was trying to get rid of gaps, so let me scroll back up. Okay.
Okay. So again, struck a couple of things, added a couple of things. Is there any questions about A? So then B, and again, this is the things to be talked about in the pre-application meeting. Submittal requirement considerations for alternative location analysis, cumulative impacts and considerations, including but not limited to. I added in here the most recently submitted annual report pursuant to Reg 7, Part B, 5B regarding the NOx and greenhouse and density targets. Please let me know if that's not the right citation in there. And then Romanet 2, the default impact area, and an explanation of the process for the applicant to propose something different than the alternative to the default impact area that is provided in the rules. Consideration of past, present, reasonably foreseeable future development in the impact area and how to evaluate those in the application. Best management practices, ESPs that an operator must or could include in their application depending on circumstances, understanding that some of them would be required, some of them would be optional, some of them are as practicable. And so I think that's a good conversation to have in this meeting. Submittal requirements for the lesser impact area exemption requests, anticipated milestones, refile amended permit status. I did strike conditions of approval. I did strike the operator's designation as a preferred operator because that was stricken in the rules. Local land use plan, and I did include topics related to surrounding compatibility, comprehensive area plans, sub-area plans, and future land use designations from the local government's perspective. I struck opportunities for collaboration. I did maintain H, but included the proximate local government from a related topics piece. And so those are the things that would be discussed in there. Is there any questions about those?
And so I will say, I don't have any concerns about the topics of discussion. I think my biggest question is, do we need this detail on the topics, or are those details better put in the statement of basis and purpose?
So I think it's important to have them in there, A, because they were contemplated to be in there in the current August draft. And so this is just a modification of the elements that were included in the current August draft, and I think there's some clarity. I don't think it needs to be limited to this, and so if they're, as we've done with other rules, if we want to indicate that, this is not an exhaustive list of things that could be talked about at the pre-application meeting, but clarity and things that, at a minimum should be, because we're also asking that if local governments are going to utilize a process, their process, and have it be utilized as an equivalent process to our process, I think we need to give them some kind of guidelines on what would be required to be discussed in that meeting. Does that make sense?
I think it does make sense. I guess I'm just kind of curious as to if we're giving the guidance to the local governments there. I don't know. I think part of it is I'd rather use 5 words instead of 50 where I can, and so I just, again, no concerns with the content of it. I'm just wondering about using all of the language there as opposed to providing the guidance about the statement of basis and purpose.
I mean, some of the language in here is worded specifically to, continue to highlight that the intent of the pre-application meeting is for information sharing, high-level discussions, and to maintain its, I think, purpose to not be a place where decisions are made, but that information is shared, and that there's clarity in what needs to happen in the application process, and really an opportunity for the applicant to receive information that they need in order to have a better application moving forward. So I think having it in the rules makes sense.
Okay.
Chair Robbins, if I may. I think that this proposal works really well for local governments that don't have a robust local permitting process. I have a little bit of concern that for Weld County, for example, when staff attends Weld County's pre-application meetings, those meetings are focused on Weld County's permitting process, their WOGLA permit. And staff generally, staff does not lead those meetings. The Weld County staff leads those meetings as it's appropriate. With this much detail being required here, I would be a little bit nervous that it might seem as if ECMC staff is sort of taking over Weld County's permitting meeting. I don't want to hinder Weld County in them having their WOGLA meeting by burdening them with a lot of non-WOGLA substance. I think maybe there's a way to sort of merge the two processes to make it fit better. I want to take a little bit of a secondary role in Weld County's WOGLA meetings. And so I don't know that this is appropriate for that circumstance.
Ms. Trask, I appreciate those points. Do you have suggested solutions?
Not off the top of my head, but I can work on some suggestions today.
I'm comfortable with that. I don't think what is contemplated here was to sidetrack or otherwise obfuscate the work of the local governments, in particular those that have healthy, robust meetings. I think it was more to just provide some parameters. But now I'm talking for Commissioner Messner, and maybe I'll let him talk for himself.
No, I agree. I think that, again, just making it clear the things that could be talked about or should be talked about in these meetings, but not exhaustive as it. I don't see that as, obligating a local government process or taking over a local government process. And again, as I indicated at the beginning, this was me putting language in there in order to be able to clarify my intent so that it was clear to the commissioners where I was going with the concept. And so with the process that we're in right now, the intent is to, my understanding of the intent is to get consensus around a concept, allow that concept to be directed to staff, and then staff actually develop the rules in a draft that would come back to us. And so right now, what I'm hoping to do here is making sure that the commissioners understand the concept, and then staff will get an opportunity to apply that into the rules as they see fit in a draft, based on direction from the commission. So that's what I'm hoping to accomplish here.
So, Ms. Trask, if you could work with the AAGs to accommodate the concern that you advocated for in a manner that addresses the concerns as being put forward by Commissioner Messner, I think we could do and both.
I agree. I'm happy to take that back and work on that.
Okay, so there, I think we were at a section here where we were talking about participants, and so just want to make sure that the additions I had in here were clear, but that pre-application will include at a minimum the operator director and the local governments. I said just local governments because further down, local governments for this consideration would be any local government within 1 mile of the proposed oil and gas location. These were suggestions that came from Adams County. And obviously the local government has the ability to decline participation. And then any state or federal agency with land jurisdiction over the application lands or minerals, CDPHE, CPW. As we've talked about before, there wouldn't be the residential portion of this in the pre-application meeting. It's a technical meeting that would be, those residents would be engaged in the pre-application public meeting. And then as well, the community liaison, if it's within a disproportionately impacted community. For the timing of the meeting, it would be 30 days. And then the waiver, I just changed meeting in there, and then results of the meeting, as indicated in the purpose of the pre-application meeting, no decisions will be made at the pre-application meeting, and that the operator will provide the written summary. I did strike the piece that talked about any agreements or decisions made because in this concept, there would not be decisions made in the pre-application meeting. And then I have this section in here around to be included in the director's recommendation in red because I'm not sure if that needs to happen or not. So that was kind of a question mark to me, but I am trying to capture as much in the director's recommendation of the process as possible. I think that's really important to capture it in the director's recommendation as much as possible. And so I'll leave that out there as a question. I think we already
just on that point, Commissioner Messner, as one commissioner, I don't have a problem if the director decides that they want to put some of this stuff into a director's recommendation and just kind of leave it at the discretion of the director whether to do that or not. That's just my musing on that slight point.
Sorry, go ahead, Commissioner.
Sorry. Is there a downside to it?
I guess that's why I'd suggest, I don't see a downside. And it's up to the director. If something pivotal comes out of that, go for it.
Yeah, I was just gonna say, I think that the discretion aspect is fine. As written here, it talks about it being an attachment to the Form 2A. So it would come to us as part of it anyway. So I think it especially makes sense for discretion if the director does have a concern with kind of what's coming forward versus topics discussed at the pre-application meeting.
Okay.
Keep going, Commissioner Messner. Thanks.
The pre-application meeting notice to nearby residents. I think we've made changes to at least what I proposed in here already. And so it's now a 1/2 mile and 4,000 feet. And so I think that needs to be changed. And then an operator will notify residents that it plans to submit the oil and gas development plan no less than 30 days prior to submitting the oil and gas development plan. And now that I'm reading that again, I'm wondering if that comports with our notice table or not. So I have to think about that a little bit. And there was some prescription in there as to what the notice was required. I think I'm pulling some of this from the existing rules, and some of this may be the existing draft rules in August, and some of this may be, I think, Adams County suggestion. And so the pre-application notice to nearby residents may need to get massaged, but I don't really think the intent is lost there. That there just needs to be pre-application notice to nearby residents for the pre-application meeting. You know what? I think we actually struck this whole piece. Now I'm confusing myself. So in the table, did we strike the pre-application notice?
Yeah, we did.
Okay, so I think this whole thing goes away then. So, because I think we've captured it in the table. And then the pre-application public hearing, this puts a little prescription and detail in what we deserve. In the table, we decided on the notice requirements. This puts a little more detail in what would be included in a pre-application public hearing.
AG Stafford, I see you visualized.
Thank you, Chair Robbins. I just visualized to make a clarification. It's my understanding we were discussing a meeting and not a hearing. So I think we need to be careful about the words we're using here. So I just want to confirm that we are talking about a pre-application public meeting.
So we're talking about a pre-application public or pre-application process that includes a pre-application meeting and a pre-application hearing. So two separate sections there. So as I've indicated, and we've talked about both through the table as well as in this concept, there are requirements based on proximity for a pre-application public hearing that needs to occur in a pre-application process. So anything above that title of pre-application public hearing is addressing the pre-application meeting. But when the triggers hit, either a half mile from an RBU outside of a DIC or 4,000 feet inside of a DIC, if I remember the table correctly, then it would trigger a requirement for a pre-application public hearing, at which point residents would be able to provide input associated with the application to the operator, for the operator to be able to gain that insight and perspective, and then could influence or evolve their application in a pre-application process.
Okay, that does not jive with my understanding of this process here. And it appears, at least in this language below, we're talking about a pre-application public meeting. And so I guess I'm a little bit confused. So maybe if we can go back to the table.
It may be complicated, but it may be fairly simple, Commissioner Messner. I think it's just,
I think
are you envisioning a public meeting or a public hearing? Yeah.
I'm sorry, I might have pre-imposed in the language meeting instead of hearing. So that could be when I was typing it at 3 in the morning. But the intent here is to describe the requirements of a public hearing and not a public meeting. Sorry, a public meeting instead of it's not a hearing. I'm sorry. That's where I'm confused.
Okay, I think that's where we're getting confused.
Okay, that was my confusion. Thank you.
So the title is wrong. I'm sorry.
Thank you.
Thanks for the clarification, AG Stafford. And I think that's all Commissioner Messner has. Are there further thoughts about those points? Commissioner Cross?
Thank you. And I guess I just have one question about the able to present, and it talks about the director, the applicant, the community liaison be present, and I think that makes sense. I'm just curious, I guess, about, do we have an idea of what the director may present at that point in time, or isn't this kind of at that point in time, operator, this is kind of what you did. We had our meeting, you kind of go forth with what you're trying to propose.
Well, that's a good question, Commissioner Cross. And so this brings kind of a concept forward that from local government land use processes. And so I'll bring it forward and you can, as commissioners, can tell me whether you think it's appropriate in any kind of public meetings or not. But a lot of times when there are public meetings associated with land use processes at the local government level, the director and in this situation where, because we have a community liaison, they are there to provide a perspective on process, right? So they're, from an agency perspective, they could say, this is what community, this is what you can expect from a process, you know, for this application as it moves through the state review process, not opining on the application, not opining on anything that the operator may present, but simply presenting process. And now that could be just the community liaison in these situations presenting that process. It could be a staff member that presents these process, but more often than not, in local government processes, the staff of the planning department is providing some perspective on that land use process, and then allow the operator to opine on whatever they're contemplating in their application, and then they can solicit feedback. And so I think the intent here was to capture that and to include that ability for ECMC as an agency to be able to provide process. I think that's good outreach by the agency to community as far as helping community better understand our process and opportunities to engage in our process, and, you know, expectations for timelines and reviews. And so that's what was trying to be captured there. So I'm certainly open for a conversation on that, but that was the intent.
Okay, and yeah, I especially like the idea of, you know, staff being there, and as you said, for the transparency and for the outreach to the community process. I think that's helpful, and able to answer questions, especially where necessary. I'm just thinking from an efficiency standpoint, if you know, a timeline of after an application is submitted, this is what you can expect, if that can be put forward in a document to try and do it, and then answer questions as necessary instead of presupposing any kind of presentation about that. But yeah.
Further thoughts? All right, AAG Davenport, where are we now?
In consideration of sort of the intent of giving staff direction to proceed with revisions to the August draft for final consideration by the commission, I think the next step may be, is the commission comfortable requesting that staff incorporate this red line into the draft to be for final consideration of the commission, or are there substantive changes that the commission would like to make before staff goes to work on incorporating these concepts?
Thoughts, commissioners?
I'd like to emphasize that that their concepts and their intent, right? So my expectation wouldn't necessarily be that they incorporate it verbatim, but that they have the ability to use their judgment and how it would apply, but that it's clear that what the intent was is this. And so I would be in support of that.
Commissioner Cross?
I was just going to say, in terms of language as well, I know Ms. Trask is drafting something, and so I wonder if we look at that draft as well.
Yeah, so I think the direction is, staff, take the concepts, don't take the words as the Bible, and feel free to wordsmith to eloquate, you know, to grasp the concepts, but do it in your own words. How's that?
Yes, thank you, Chair. I think we've got that direction.
Anything further on that point? All right, AG Davenport, what's next?
Thank you. I'm going to stop sharing my screen on this document then and return to the other document, which is where that I sent to the commissioners yesterday, the parking lot, for lack of a better way to describe it. I don't know if we've completely dealt with this area of evaluation process yet, and sort of how we've already dipped our toe into this when Ms. Trask appeared to start to have discussions about that and parked it. So I'm referring to the AOE process. I think we may have already dealt with the pre-app process. But it's this section, and then if I can scroll down to this language, which we've already started to talk about, I think we need to reach some consensus or direction to staff on how to deal with AOEs.
Well, I mean, just some initial thoughts on this. I'm comfortable with the direction from Commissioner Messner that the burden will at all times remain on the applicant. I'm comfortable with the applicant taking up the default area of evaluation. I'm comfortable if the applicant wants to do something different, they've got the burden to prove that that makes sense. But I also want to recognize the concerns raised by Ms. Trask that at times the director should have the opportunity to provide perspective that a different area of evaluation is necessary on a case-by-case basis. And in doing that, the director doesn't somehow obtain the burden of proof on that. So I don't know how to like massage all that into words on a page, but that's kind of the direction that I'd like to see this go. Commissioner Oath?
I think that makes sense to me. I mean, maybe another way of saying the same thing, or another thing that I'm thinking about here is we've been talking about this as if the operator wants to deviate from the area of evaluation. And that sort of means if the operator wants to expand it, right? Except for some of the circumstances where they may be geographical relief. And so I think it's important. I think what's happening here is the point is if the ECMC staff, CDPHE, or CPW, or others who may be involved, or others at a community meeting are indicating that they think that area should be expanded, the burden remains on the operator either way, right? To sort of explain why the area of evaluation they move forward with is appropriate, whether it's the default or it's an expanded one. And if there's sort of not consensus around that, the burden is theirs. Does that make sense?
Other commissioners desiring to weigh in on concepts here?
I think that makes sense, and yeah, I agree, and I know Commissioner Messner is saying no decision made, and I understand that no decision made. It's sort of, hopefully there's, I don't want to say consensus because it's not an agreement, but some understanding of if CPW, if CDPHE have a concern with the default and they suggest something else, yeah, it's kind of up to the operator to either prove why they're not taking that in, that recommendation, or they are taking that recommendation.
I'm good with that.
Commissioner, or I'm sorry, Ms. Trask?
Thank you, Mr. Chair. I wanted to point out in current rule 304B2C, this is the ALA. We have language that says, and this is the current rule, if an alternative location analysis is required, the operator will prepare a narrative analysis that identifies all potential alternate locations from which the targeted minerals can be accessed. I'm wondering if we could have similar language here for the area of evaluation that says something, something similar to the ALA, that the operator will prepare a narrative analysis that identifies all potential sources of impacts, or something similar, just to put some guardrails on how the area of evaluation is determined. I would anticipate that generally operators would not voluntarily expand the area of evaluation. And so I think it's important to have some language in the rule that provides some direction to operators that if there is a potential source of impact just outside the default, that needs to be included in that evaluation.
Commissioner Oath?
Ms. Trask, I appreciate that, but I'm not sure about that, with all due respect. That sort of sounds like then we're expanding the area of evaluation for them to defend what the area of evaluation is, right? Like having an identification of other potential sources is in some ways part of what the analysis is. But I understand what you're getting at, and maybe it's, if a different area of evaluation was recommended or discussed by, during the pre-application consultation meeting or the public meeting, then I think what you're getting at is that the operator will provide a narrative explanation of what potential sources were concerned and, why they did not agree with such, proposed or suggested expansion, or why that sort of source should not be encompassed in the area of evaluation. Is that consistent with maybe what you were getting at?
Ms. Trask?
I think so. I might alternatively suggest similar language that we have in current Rule 304 B2 A Romanet 2, which is applicability for the ALA again. So not the area of evaluation, but sort of a similar condition for the ALA. That it applies to any proposed location for which the director or commission determines that an alternative location analysis is necessary to evaluate whether the proposed location reasonably protects and minimizes adverse impacts. So again, I'm happy to get off this topic at any time, but I do want to stress that if there is not a means for staff to require the addition or the expansion of an area of evaluation, we can sure suggest it, and a wise operator would take that suggestion and use it. But I do have a little bit of hesitation about leaving the operator to make the sole decision that then staff has to work with. I understand that in the director's recommendation, staff could indicate that staff disagrees with the area of evaluation that the operator proposed. It could be problematic in staff's review of the cumulative impacts analysis. Because if we're not able to include something that we would have wanted to include in part of that evaluation, then it makes it difficult for us to make a recommendation either way. So I will take whatever direction the commission gives me, but I do have some concern with this proposed direction.
So Chair Robbins, I've got a couple of thoughts here. I do think that there's logic in providing the director with the ability to provide input to the operator on, expansion of impact area if that's necessary for the review. I think that, well, whether that's the director, whether that's, another agency, whether that's community in some respects, but would also, at the same time, in an attempt to create some regulatory certainty, that's why we have developed a default impact area. And if our default impact area generally are not at an area that generally almost always is going to capture these things, then I think we need to reconsider our areas of evaluations or our impact areas, because in my view, a deviation should be relatively rare from an impact area that this commission determined as the appropriate impact area. Now, that acknowledges that there could be deviations to the areas of evaluations. As Ms. Trask indicated, the burden remains on their operator if they choose not to take the suggestions or the direction provided by staff or the director or other agencies. And the tool, the enforcement tool that staff has on that, if it's a necessary piece of their evaluation and they can't properly do their evaluation of the application without that, is a recommendation of denial that would then go to the commission. And I think that's an appropriate tool, and an operator would choose to not listen to staff and their expertise in whether or not there needs to be an expansion of the area of evaluation. And so I'm comfortable with the process that we're suggesting here, because I think this is a standard process, as I've indicated, for lots of land use applications. And again, the tool that the staff has, if an operator is choosing not to listen to their explanations as to why they feel like they need an expansion in the area, or any other element of the application for that matter, is to provide a condition of approval on the application or recommend denial of the application to the commission, and the commission maintains its ultimate authority to make a determination of whether or not we agree with the director's recommendation or not. But as I indicated before, the vast majority of the time it would be in agreement with whatever the director's recommendation is. So I like the direction that Commissioner or Chair Robbins has provided on here. I think the direction is clear. It provides that clarity, and I'm comfortable with what we've got.
Ms. Trask and AG Stafford, are you comfortable with the direction and the concept of trying to draft this up for us?
I might ask, Chair, that we're given a little bit of leeway to wordsmith a little bit and maybe provide a couple of different options for the commission to
Yeah.
review.
I think that's great. Leeway provided.
Okay, because I do value and agree with Commissioner Messner's intent here. I think that the burden does need to be on the operator rather than staff. I am in total alignment with that. I just don't want to hobble staff from having the ability to make recommendations to the operator and creating sort of an adversarial push-pull situation during technical review. So maybe we'll come up with a couple of different red line options for the commission to review here.
I think that's great. Commissioner Ackerman?
Thank you. I'm in agreement with that as well. And just wanted to flag, it may already be in the AG's notes, but wanted to flag that we've kind of shifted obviously to using the term area of evaluation. We don't have a definition for that. We do have a definition for impact area in the definitions. I don't know if that's a simple transposition into area of impact, but I just wanted to flag that as a point to look at for the AG's office and staff.
Mr. Chair,
Yeah,
I believe, at least in my own mind, the consensus was we are an area evaluation is just changing the name of the impact area in our regulations. So the statutorily defined impact area is just renamed as the area of evaluation. I think this concept originally came from Commissioner Oath. So if she has, if that's not the way she proposed it, I hope I'll be corrected, but okay, I'm getting a thumbs up. So, yeah, to the extent we have a definition of AOE in the in the draft rules. It's just simply to say that's the impact area as defined by statute. It's just called the area of evaluation in our rules.
Okay. Are we good on this point?
In an effort to capture what we've gotten to, and I recognize staff has already said they're good on the direction, I did attempt to summarize the direction in red line on your screen. It's there right now. The things that were appeared previously I deleted because I think they're dealt with otherwise, except for this down here. I'm not sure if this is part of the direction as well here, that the director's recommendation include a recommendation on appropriateness. Is this, sorry, let me scroll back up. Is this essentially the direction?
Yeah, I mean, I think that captures it on my end. All right, I'm seeing no one with concerns, so let's go with that direction. I think we've got 2 or 3 more areas to cover. Let's take a short break and come back at 11:26, and then we'll cover the remaining areas. All right, we are back. Colorado Energy and Carbon Management Commission, September 26, 11:26. And we have a few other items to go over. I think before we wrap for a bit, AAG Davenport, you're doing a good job of leading us through various scripts. Maybe I can call upon you again.
Thanks, Chair. In my view, what we've identified to still provide direction to staff / reach consensus is how to deal with CIA, ALA, and in caps and how preliminary siting and what happens with OGDPs. Still to deal with maybe specifics in regard to mitigation hierarchy and adding content to an ALA. That's what I'm aware of. So I'd like to take those in turn if that's the commission's pleasure.
That's fine with me.
Okay. I'm going to share my screen again with the caveat that I think this is what I understand to be a proposal from Commissioner Cross that was discussed in hearing. I don't know that it's a complete proposal. So what I'd like to start with is opening it up to Commissioner Cross to correct anything you see in the bullets or add to anything you see in the bullets.
Sure,
That sounds fair, Commissioner Cross. Are you willing to be put on the spot?
I am. And thank you for that, AAG Davenport. I think for the CAP seeking preliminary siting approval here, yes, on the first bullet, the CAP application will include the 2B that covers the proposed locations. Yes, on the second bullet, the CAP application will include the cumulative impact analysis for the proposed locations. The subsequent OGDP will not require the 2B or the cumulative impact analysis. And I would note here that's unless the change warrants a new cumulative impact analysis or 2B because of changes. And I would highlight here, this is also where after consideration of discussions with allied local governments, those changes can be beyond just land use changes. Again, I think some of the examples that were given were natural disasters, flooding could change the nature of things. It could be things of maybe high priority habitat has been added or decreased, and maybe there's plugged and abandoned wells, all things to take into consideration and not necessarily require in some circumstances the new cumulative impact analysis or 2B, but that's kind of the decision that will be made at that time. But generally, if there's not a change, then there won't be the subsequent 2B and CIA. I would add a bullet after this and say the CAP application will include the alternative location analysis for each proposed location as it does in 304. And similar with the above, the alternative location analysis will not be required at the OGDP stage under a PSA, so long as there's not the changes noted. And then talking with Ms. Trask, I think the 2F would still be required, as that's got different information than the 2B. And then where it's not seeking a PSA, and I guess I don't know if it's worth throwing in there, if it's partial PSA, you might not need for that location, you might not need, as long as there's not changes, you might not need the new ALA, the new CIA for that location, the new 2B. However, for the CAP overall, you would still need everything. And if there's not PSA at all, then you'd still need to do the 2F and the subsequent 2B. You'd still need to do the subsequent cumulative impact analysis. You'd still need to do the subsequent ALA.
Does that cover it, Commissioner Cross?
I believe so.
Questions from fellow commissioners to the concepts? Commissioner Messner?
Thanks, Commissioner Cross. I think this captures what we had talked about. I do have a couple of questions though. So I think you and I had some conversations during this conversation about the in a situation where there's caps that have preliminary siting or seeking preliminary siting approval, to have this big, robust, cap-wide cumulative impacts analysis that includes information about the individual sites, and that there would be circumstances where individual cumulative impacts analysis may be required. And I still am calling them kind of cumulative impacts analysis lights, when there's significant changes or things that need to be addressed because there's been some shift in the things that you've indicated here in the application. And so I appreciate all that. I think that generally captures our conversation, but I think where I'm still struggling, and maybe you can help me here, is the variability in the level of detail that's provided in some of the CAP applications, even when they're considering preliminary siting, as far as the commitment to certain technologies within the CAP. And so how are they applying that cumulative impacts analysis on the CAP level and still having it applied to the individual levels if there's still uncertainty as to the technology they're going to be employing? And should that technology be different, either more beneficial or less beneficial at the OGDP level, should that require some additional cumulative impacts analysis at the OGDP level? Is that, am I clear with my question? You're muted.
Apologies, I hit unmute, and it didn't unmute. It does make sense, and I think this would, in my mind, fit with a description of changes to it. So the way I see it is, obviously we'll talk about pushing for electric drill rigs. We're going to talk about pushing for the best we can. And the hope is, if the planning is put into complete PSA, that the operator will be able to come forward of, this is what we're able to do. And so there hopefully shouldn't be too much in terms of what's changing. But my envision is that at the cap stage, the 2B, the cumulative impact analysis, will be what they can commit to. And so there's obviously the hope that if they can't commit to, and we'll use drilling rigs as an example, but they're saying, we're still having discussions, we're hopeful, okay, but what you're committing to at that point in time is the tier 4 or whatever the case may be. And so the 2B, the cumulative impact analysis, will be based on what they can commit to. I think that if we deem that approvable and it moves forward at the OGDP stage, I think at that point in time, a change could be, yeah, we're going to have lower emissions. And so we can update the 2B at that time, because now we are able to get that electric rig into place where we weren't before. And I think when it comes to the analysis overall, I kind of agree with the light. I think that can be done, whereas the quantitative and qualitative descriptions and the cumulative impact analysis are done up front. I don't think you need to do an entirely new cumulative impact analysis. If you're just doing that, the narrative can be provided to kind of update those parts to say, listen, because we now are being able to utilize the electric rigs that we could not commit to before, we are going to have the decrease in NOx, we are going to have the decrease in noise, et cetera, and kind of describe it in those parts and then update the 2B. I think to me, the key is requiring an entirely new 2B overall, requiring an entire new cumulative impact analysis overall, the new ALA overall. That's where the disincentive to do the cap kind of comes in. And so if we do want to try and promote that landscape level planning and trying to get things done ahead of time, having that requirement to redo that analysis, unless there's a change, is more of a disincentive. And so, yeah, I think in short, at the cap level, the analysis will be done on what you can commit to, and then you can update. And one would hope that if you are improving it, then it's going to be fairly simple and something that operators would want to talk about anyway, to say, listen, we went through the cap analysis before, and everyone agreed that as proposed, it was protective of public health, welfare, safety, environment, and wildlife resources, and we've made it better. So I think in that situation, that's something that would want to be talked about, would want to be updated, et cetera. But the basis on it should be what they can commit to.
Okay. I'm in agreement with you here. I think that makes sense to me, but just a couple of additional things. On the page here, it's indicating that we still need a regional cumulative impacts analysis. So I think that's not right. That's not the case.
So, and maybe it's better to have Ms. Trask come up here. Initially, I thought,
what I'm saying in the just so you understand, so in cap seeking preliminary siting approval, on the last line there, it says still need a regional 2F. I understand that, but do we need a regional cumulative impacts analysis as well if we're doing this robust cap-wide cumulative impacts analysis already?
I would think that the regional cumulative impact analysis is kind of already covered in what's being done as you're going site by site through that.
Okay, that's what I'm thinking as well. But that cumulative impacts analysis for this situation should cover both regional and individual locations. It's kind of the
correct,
the big daddy, right? So yes. I mean, it's covering everything. And so
yeah, I envision them as they're going through their 315B analysis to talk about not just the site specific, but also saying as a whole, this is what's in the cap area with, and it's going to talk about the impacts overall to water. So
Okay,
Appreciate-
I think that's good.
Yeah, appreciate that. And thanks, Commissioner Cross. Recognize Ms. Trask?
Thank you, Chair. I agree with everything that was just said. My question, I suppose, is if for preliminary siting approval, if for each location, there is a Rule 315B cumulative impact analysis, that would, just thinking from a sort of a workflow perspective, and assuming the default area of evaluation or impact area, that is going to look at the default. So let's just say 1 mile around each proposed location. That won't cover things such as expansion of utility lines or pipelines or access roads, utility corridors, electrification, new highline power. That really is only looking at that 1 mile radius around each proposed location, and it's not capturing that landscape level potential impact. And so that, for me, I guess I'm still curious to know, is the Rule 315B cumulative impact analysis for each location enough? Or should there be some additional form of information included in the cap whereby the operator takes that bigger view over the entire cap area?
Commissioner Cross?
thank you. I'm trying to, without looking at the rules, trying to remember. I know that some of the maps talk about the new access roads, et cetera. So I know that that's something that's already, as part of the submittal requirements, talking about what that's going to be. But you're looking at an analysis of you're asking about an analysis of what those new roads would be, what those new transmission lines, et cetera, might be as well, correct?
Correct. And maybe that's something that we just sort of build into the current Rule 314 cap application requirements, whereby the maps also have sort of a companion narrative that describes the impacts that are illustrated in the maps.
I think that makes sense. It's certainly something that's already being compiled and noting like this is how we plan to develop this overall. So I think having that narrative to say, and showing around where those roads are going to be, this is near a water source, this is near a school, et cetera. That's the kind of information we're already seeing in the maps and what we're looking at. So I think it is appropriate to have some narrative around the description of those impacts.
So Commissioner Cross, I guess I'm confused again, because I thought that we were talking about this being the big daddy so that it did cover the regional and the individuals when there's preliminary siting. So yes, it would be direction to staff to require both of those things, right? So to have both, but they need to speak to one another, right? So I mean, the requirements for the regional or bigger cumulative impacts analysis, need to capture those regional pieces, whether that's, utility line infrastructure or traffic or whatever that regional piece would be. And then the individual OGDP cumulative impacts analysis would capture, elements that weren't included in the bigger, broader picture, and needed to be highlighted as well. So it was, the the one cumulative impacts analysis that would cover all of those things in this particular situation and would only need to be shifted if there was a change in circumstance at the OGDP level. So that cumulative impacts analysis needed to be regional and location specific. Am I
Yes.
wrong there?
No, I think that is the case, and now I'm trying to wonder of like how we can maybe adjust the language in 314 to address that. I know that 2F is looking at some of the estimates on that kind of information. But no, I completely agree. I think this is looking at what's happening on the landscape level as well as what's happening at the individual level.
Anything further, Ms. Trask, you want to weigh in on?
No, I think this is going in the right direction. I would again ask that to give staff some flexibility to rewrite the language in 314E10. I would want to minimize any duplication between what is coming in on the Form 2B or the individual cumulative impact analyses for each proposed location. We don't want any duplication there, but where there are gaps in the current draft, where we're not collecting that sort of landscape level cumulative impact analysis, I think we can provide some revised red line language that will clarify that so that it's captured.
Okay, I think that's fair. Just like in the last one, you've got direction, draft accordingly, and we look forward to seeing red lines. AAG Davenport.
Thank you, Chair. In an effort to keep this document capturing commission consensus direction, is this missing anything? Many major points, concepts that now needs to be included or changed?
I don't think so. All right. What's left?
Well, there may be other things. What I'm gonna do is scroll down now to the two last, at least ones that I parked. Topics raised by Commissioners Messner and Oath. The highlighted text there. They're separate topics.
Commissioner Oath, do you want to go first?
Sure. I think the one that is relevant that I had added was about wanting to give some direction to staff to please add some language related to the mitigation hierarchy and to kind of draw from proposals both from the ALG and Oxy proposals on this, but to give some latitude there in terms of precisely how to do that. But I think it is important that that get included, that concept get included.
Ms. Trask?
I was just going to respond. I think we can do this. I don't think that that's going to be a difficult task for us.
Ms. Stafford, I see you visualized as well.
Thank you, Chair Robbins. Just to clarify, with Commissioner Oath, at least on the parties that this discussion, I just want to clarify, it was the ALG and Oxy red lines.
Those are the ones I can recall. If other commissioners have ones that you are top of mind for you, please chime in.
Those are the ones I recall as well. Others? Commissioner Messner, you'd raised your hand. Did you have something to weigh in on?
I do. I'm certainly happy to defer to other commissioners if they've got additional thoughts before me, but so a couple of things in the application of the mitigation hierarchy and how that language happens is, and this is highlighted in the ALG's piece. Adams County also had some considerations of this. There was a few others, but I mean, I think they all are relatively similar in their approaches. But the desegregation of the mitigation hierarchy ends up being a really important piece. So if we look at the existing August draft rules, some of they a lot of times avoid, minimize, and mitigate get included in there. Sometimes it says avoid, minimize, or mitigate. And so those are all kind of thrown around in there. And to me, that's not clear as to the application of the mitigation hierarchy. And so that desegregation, and there's good language in the mission change statement of basis and purpose around that desegregation and how the mitigation hierarchy gets applied, particularly in the SBP associated with the 1200 series, but how that you first avoid, and then you, and I'm not going to get the language exactly right, and then you minimize those impacts that couldn't be avoided, and then you mitigate those impacts that could not be avoided or minimized or something like that. But that's, to me, getting to the proper application of the mitigation hierarchy from a philosophical standpoint. I think ALG also has some good suggestions in theirs. And I think also, well, that piece with the mitigation hierarchy ends up being important to me. And I think there's lots of different places that could be clarified, because I think also in, you know, operators applying the mitigation hierarchy and their presentations to us, they're all over the place as far as how they're applying the mitigation hierarchy and where they're considering things that are being avoided, where they're probably more of a minimization or a mitigation proposal. So even if there needs to be an additional section in the statement of basis and purpose that builds out that mitigation hierarchy, utilizing, you know, the definitions that from mission change and the application of mitigation hierarchy that's in the mission change SBP, I think that's helpful to have in this rule section, in this SBP for this rule section as well, or this rulemaking. I mean.
Okay, AG
If I may,
Stafford?
Chair.
Yeah.
And so I guess my next question here relates, I think, to that very point. Because it seems to me that this more fulsome discussion of the hierarchy is something that might be more appropriate for the SBP and not necessarily rule language. And so I just want to, I guess, throw that out there for your consideration. That I guess there is a little bit of, I have a little bit of hesitation spelling that out in the rules, I think, in the way that I'm currently looking at it, but I'm open to better understanding the necessity for that rather than it being in the SBP.
Commissioner Messner?
So let me give you an example. So I think there's a couple different ways to approach it. One is I think the mitigation hierarchy needs to be in the definitions. It has to be a defined term. I think that there needs to be an explanation of it in the statement of basis and purpose, so that there's clarity around how the mitigation hierarchy gets applied. I think the term mitigation hierarchy can replace in the rules where it's currently being utilized, avoid, minimize, and mitigate. But then in the decision points throughout the rules, you know, so for example, in an ALA, having the inclusion of an operator, you know, showing, because we indicate in the statement of basis and purpose in the mission change already that the ALA is our primary tool for applying the mitigation hierarchy and siting of oil and gas locations. And so therefore some consideration of the term mitigation hierarchy in the ALA, you know, would be, I think, helpful. But then in, you know, where in how we make decisions within the rules, so whether that's with the director's recommendation, whether that's with the commissioner decision-making tree, you know, having that clarity in there about how we apply the mitigation hierarchy and the desegregation of it, I think can be helpful in the rules, but do agree that a lot of conceptually of how that gets built out could and should be done in the statement of basis and purpose.
AG Stafford.
Thank you, Commissioner Mesner. I appreciate that explanation, which brings up a couple of other questions for me. Just the first one, so you're suggesting a new definition for mitigation hierarchy. Did I hear that correctly?
So my suggestion is right now in the rules, it says in some places avoid, mitigate, and avoid, minimize, and mitigate. In other places it says avoid, minimize, or mitigate. And all of that is really referring to the mitigation hierarchy and understanding that the mitigation hierarchy brings in both the definition of avoiding adverse impacts. It brings in the minimizing adverse impacts definition. It brings in other things into the mitigation hierarchy piece, but I'm saying in lieu of using avoid, minimize, or mitigate in the rules, you could replace that with mitigation hierarchy. But I guess it's a question whether if we use the mitigation hierarchy term to replace avoid, minimize, and mitigate in rule language, does that need to be defined or not?
Okay. And so I think I understand what you're saying there. And at least from staff's perspective, we have some big concerns about what that would do to other rules that are not noticed for this particular rulemaking. You know, where the term avoid, minimize, and or mitigate appears. I'm scrolling through, I'm going through the rules as quickly as possible here. And there are other spaces in different rule series that have not been noticed for this particular rulemaking. So I really want to ensure that we're not proposing changes that might lead to confusion with some rules that we haven't proposed for changes in this particular rulemaking. So at least from staff's perspective, I want to ensure that that is being thought about here.
AG Davenport, you're the attorney to the commission. Ms. Stafford's the attorney to staff. Can you provide some perspective on this point?
Yes, I can. Maybe. The scope is something that is a concern in any rulemaking, and to the extent that the commission is requesting a redefining or a new definition that may result in amending rules that were not addressed in the notice, did not appear in the June draft, we do need to look carefully at scope there. I'm not yet opining, having not looked at this issue previously, that there are things that are definitely outside the scope, but it is something that's going to have to be considered and considered carefully as to whether or not adding a new term that results in changing rules that hadn't previously been amended by drafts or included within the notice can still be defined as within the scope. Yeah.
Is a solution possibly just to limit this to the SBP and using that to explain what avoid, minimize, and mitigate means in this regard? And that's to either of the lawyers on the call.
AG Stafford, do you mind if I go first? Still need to make sure it's within the scope. Yes, I think so. However, I think we still also need to ensure consistency with prior SBPs, and consistency with the rules themselves. If all we're doing is providing intent within the SBP.
AG Stafford?
I agree with my colleague.
Okay. Commissioners? Commissioner
So,
Messmer?
Mr. Chair, I mean, I appreciate the whatever legal considerations need to be made here. I'm struggling a little bit because we have avoid, minimize, and mitigate all through the rules, and so that is the mitigation hierarchy. shortened. And so whatever needs to happen from a legal standpoint, that's fine. I think the intent, at least that I'm hearing from a couple of commissioners, is that we clarify and apply the avoid, minimize, and mitigate in the rules as we have with the mission change rules throughout the mission change rules. And in order to make it easier for operators to understand the rules and to make it clearer to operators on how to comply with the rules and make it easier and clearer for commission and commissioners in applying the rules, to just have some clarification in there about what avoid, minimize, and mitigate means, how it's applied, and that it gets applied in decision criteria as it is intended in the mission change rules, in these rules as well. So I think it feels a little bit much ado about nothing here, but I think it's an attempt to try to be clearer. But that's my perspective.
Others with thoughts?
I feel I should weigh in here, Mr. Chair, but I guess I'm not sure what the decision point is or where we are exactly in the conversation.
AAG Davenport?
Well, I'm just wondering if it's possible for me to make a suggestion.
Go for it.
The
We're kind of treading water here.
the direction that I have heard, though I'm always happy to be corrected, is there needs to be additional clarity provided regarding the mitigation hierarchy and how that works within the rules. And the commission would like to see that clarity reflected in either the SBP or the rules themselves. And my suggestion is, could you give the discretion to staff to provide, recognizing that direction, to provide a proposal to the commission for consideration?
I'm fine with that.
I am as well. I mean, I think that's where I generally started with the suggestion, of looking at sort of the proposals from a number of parties as to help inform that, staff's thoughts on the best way to move forward.
And also recognizing that staff is directed to take a look at the ALG, Adams County, and Oxy red
Yeah.
lines, as well as the mission change SBP for clarity on this point and suggestions to be considered.
Do we have at least one more? I'm fine with that.
I'm fine with that.
Yep.
I'm good with it.
All right, that's 5. I'm fine. Thank you, Commissioner or AAG Davenport, for helping refine our thoughts on that.
Thank you. The last matter that I have on my list is in the parking lot, is highlighted here. And I recognize that I started to type and then the talking got faster than my typing. My typing is not great. The topic is to add information or to add to the contents of an ALA whenever it is required. The first one I've written down there, but I know there are more in the proposal.
Mr. Chair, that was me, so I'm happy to just try to make it clear.
Go
I think
for it.
Commissioner Cross, you indicated that the things that I was bringing up, and these are coming from the allied local governments, were already in the rules, but they were struck as part of the August rules, as best I can tell. Now, if I'm incorrect there, please let me know. But there are a few things that to be included in the contents of the alternative location analysis that were recommended by allied local governments for re-inclusion into there, which includes all proximal existing and permitted oil and gas locations, all disproportionately impacted communities within 2,000 feet of each oil and gas location analyzed in the alternative location analysis, any major transportation corridors, including but not limited to an interstate or state highway or railroad within the impact area, and maps of high priority habitat within 2,000 feet of each location. I believe, and I'm not looking at Adams County's red lines, but they had similar suggestions or desires for re-inclusion of those. So if those are included in the August draft and I'm just confused, please let me know. But my understanding is that that was struck, and I think that those would be important things to include as contents of an alternative location analysis.
Mr. Chair, may I
Yep.
back to the question briefly? Thank you. Commissioner Messner, is it fair to summarize your proposal as just a return to the June draft on the contents of an ALA? Or are you proposing additional things beyond which were struck by
So
the?
I believe that that's accurate, but I haven't compared the June draft to the ALA or ALG's red lines. I just read the ALG's red lines and thought that they were a good idea for inclusion as contents. And so if that cross-reference is done and it is a return to the June draft holistically, then yes. I just don't know that to be the case, and I don't know if I have time to cross-reference that right.
Ms. Trask?
Thank you, Chair. Commissioner Mester, I believe that the items described here have simply been moved from the ALA into the Rule 315 cumulative impacts analysis. Proximal existing and permitted oil and gas locations, that is in 315B. The disproportionately impacted communities is still in the ALA. It's just been moved further down in the list. And I believe that the transportation corridors are also in 315B. I can take a moment to confirm these, but I'm pretty sure that everything listed here is either still in the ALA, just moved to a different part of the ALA, or has been moved into Rule 315. I'll double check on each of those.
I appreciate it. I mean, again, because there's so many red lines in whatever draft I'm looking at that I'm sure that I'm missing stuff. And so if that's the case, that's fine. I do wonder though, if there is something that is shifted to a Rule 315 cumulative impacts analysis that should also be included in contents of an ALA. I wonder if there's a benefit to having it in both places for aid in evaluating whether or not the ALA is the appropriate, has determined the appropriate location or not. For example, oil and gas locations, transportation corridor maps, high priority habitat, so on and so forth. And so if there was something shifted to 315, I don't have a problem with that, but maybe explain why it's in 315 instead of the ALA, or should it be in both?
Ms. Trask?
I'm happy to take a look at that and see what has been moved and provide an explanation as to why or whether it should be retained in both places.
So is this something we can, again, provide staff to look into and come back to us on?
Unless there's an objection from a commissioner, that's what I see as the direction to the commission or to the staff, is to examine the June draft plus the ALG red lines to see either which topics were struck in the August draft or if there are any additional topics that may have been added in the ALG red lines. And furthermore, to see if there's anything that was moved to a cumulative impact analysis and out of an ALA, and return to the commission with a staff recommendation
Yeah,
on well, really probably it sounds like more just information from staff on what's where and if there should be anything that was moved from an ALA to a CIA, if that should also now be returned so it's also considered in the ALA.
I'm comfortable with that.
Ms. Trask, that was a lot of words. Hopefully that's not a big lift, but
No, I
yeah.
think we can cross-check that fairly easily.
Okay, so direction is given on that point. Does any commissioner have any other points for discussion this morning? Commissioner Cross.
Thank you, Mr. Chair. One additional thing that I have kind of added to my own miscellaneous issues here is perhaps some language addressing the concern I raised on the notice extensions not affecting party status. And then I just note that obviously we still have the 316C ESPs and the 604 to discuss, but we're also waiting on the comments.
Yeah, and so I agree with the point you just made that AG Davenport just typed on the affected party status. With regard to the point on 604 and 316C, I think it might be more prudent for us to get party filings as we indicated we want to receive, and then we can lead off on that at our next hearing after we've had some stakeholdering on those points. That would be my suggestion.
I agree. I just wanted to make sure that's what I
Yeah,
had in my list
it's-
as additional.
Yep. That's fine. Commissioner Messner, then Commissioner Ackerman.
No, I was just wondering what we were gonna do with the SPs and 604, so that's fine.
Okay. Commissioner Ackerman.
Thanks, Mr. Chair. I would like to follow up with some recommendations on our reclamation discussion yesterday.
Oh, yeah, go for it.
Okay, great. Thank you. Let me get to my notes here.
Mr. Chair,
Yeah.
while Commissioner Ackerman is getting to his notes, I would just briefly like to return to the topic raised by Commissioner Cross to address the intent that notice extensions or receipt of notice does not affect party status. Commissioner Cross, may I take that as direction to staff to return with a proposal? And the reason I say that is because I think it's possible that could either be SPP language or rule language, but I'd personally like to take a look at what seems to be better in that regard, and to come back to you with a proposal, recognizing the intent is somewhere we need to express the concept that receipt of notice or an invitation does not confer party status.
I'm fine with that direction.
Yeah,
Thank you.
me too. All right, that gave Commissioner Ackerman a chance to get his thoughts together on reclamation.
It did, thank you. And my ultimate recommendations here are going to be based in Regulation 904, and if needed, I can project that, but I think it'll be relatively simple. As a reminder, we were discussing how we better incorporate reclamation into cumulative impacts. And one of the questions that came up from Commissioner Messner is how we currently do that. And so I did some looking, and I certainly hear pretty consistently that reclamation is an important part of analysis of cumulative impacts. So I do feel better inclusion of reclamation in our cumulative impacts tracking and continued improvement of reclamation efforts is applicable to cumulative impacts. So far, the annual cumulative impacts report really has only addressed reclamation as a function of total reduced surface disturbance acreage of operations after interim reclamation. And so we put out a figure of what the disturbed acreage is in the annual report, and then we put out a figure of what and this is very simplistic, a figure of what the acreage is totally after interim reclamation. Otherwise, we don't really talk about long-term or ongoing reclamation in the cumulative impacts report. I do think we could add some other annual reclamation metrics to that report. And I think that we could improve that reporting through the continued pursuit, as I've talked about a number of times, of real-time surface disturbance mapping tool improvements, as we've talked about during these hearings. And so in Regulation 904, we state, this is 904A1, we mandate the report from the director. We state that it should have data gathered regarding anticipated and existing impacts in the cumulative impact insider, including but not limited to data regarding impacts to wildlife resources, including high priority habitat, and a comparison of water volume data reported pursuant to rules that follow. I think we could simply add a reference to reclamation in there, and that does give us an opportunity to more closely tie reclamation with cumulative impacts analysis. We can certainly talk with staff about what metrics can be currently included. I think we could include some data immediately going forward. And I think what we could report going forward from COGIS, and again, these are just suggestions from staff, and I think we'd have to hash that out. And that's beyond, it's included in the scope of this hearing, but kind of beyond that. But I know that in COGIS, we can assess how many wells that year are eligible for final reclamation. We can, and those are wells that are abandoned locations, dry and abandoned, or plugged and abandoned. I know that we can assess how many wells that year have achieved final reclamation. And I think to the extent possible, we could report on other categories of reclamation status, whether they're in interim reclamation or no status. And then I think that will at least give us an idea of kind of where we're going from a reclamation status annually, kind of on the larger picture. And then I think we can work with staff, as I've talked about, to help develop a surface mapping tool that includes actual acreage totals for reclamation. And we can drill down to acres reclaimed in the cumulative impacts report as we improve those tools. And so I would suggest that inclusion in the reclamation or in the regulations, and then a follow-up with staff to further discuss what can be reported on annually, and another follow-up with staff, making sure that we wrap reclamation into further discussions about improvement of surface disturbance tools. Kind of ancillary to this as well is one more suggestion, and that is that we require already in 904A that the director, based on consultation with CDPHE and the Department of Natural Resources, then creates the report. I think it would be appropriate to add CPW in there. I certainly understand that CPW is a child agency within the Department of Natural Resources, but based on CDPHE and CPW being our primary consultative agencies, I think it's appropriate to include CPW in there, and I think that will help make sure that we kind of more formalize an opportunity for CPW and CDPHE to have some impact and suggestions in our cumulative impacts report. And I think that kind of leads me to my final recommendation, which is including in the statement of basis and purpose language that kind of formalizes that consultation. And I would suggest that that consultation focus on specific annual areas and or issues of concern, kind of an ongoing watch list type approach that CPW and CDPHE can raise issues that they're concerned about, but maybe not ready or able or appropriate at that time to take exact action on. So just to summarize, add CPW as an agency that we consult with, add reclamation in the list of things that we include in the report, and then follow up with staff, as I've mentioned. And I'm happy to volunteer to the extent that we need commission involvement in that. So those are my recommendations and suggestions to kind of improve how we include reclamation and cumulative impacts.
Thank you for that, Commissioner Ackerman. I'm in agreement. Appreciate you leading off on that. I think nodding of heads in the up and down fashion from the rest of the commissioners. AG Davenport, thanks for capturing that.
Thank you, Chair. I did my best. Sorry to interrupt you.
Go ahead.
I'd like to briefly give, if I may, the opportunity to staff to indicate if that direction from Commissioner Ackerman was clear.
Ms. Trask?
Yes, I believe it's clear. Thank you.
All right. Commissioners, I believe we have exhausted the preliminary round of issues in the cumulative impacts and enhanced systems and practices rulemaking. With that being the case, our staff has a lot of work to do I want to conclude today by thanking our staff for the Herculean efforts that they have undertaken to date. I want to thank all of our stakeholders for the massive amount of additional input that has been constructive to the process. And I want to thank my fellow commissioners for the good work that we've done. We've still got a ways to go, but I think we can get there. I believe we were going, and Hearings Manager Thomas, if you want to elevate, or AAG Davenport, you can help. But are we pushing the next hearing date to October 8th? Is that right? Is that where I ended up yesterday looking at calendars?
Yes, that's correct. Next date is October 8th and the following date is October 15th.
Okay. And then in the interim, we're going to receive input on 604 and ESP by October 2nd. That hearing order went out yesterday, as well as the drafts that were daylighted. So we'll look forward to getting that. AAG Davenport, anything in closing, and maybe remind us about what we ought to be thinking about on the record.
Thank you, Chair. We've had this conversation a couple of times in regard to closing the record, and my advice hasn't changed. Again, the commission may close the record today. I believe that's an indication that the commission is in a, to put it bluntly, don't call us, we'll call you posture in regard to stakeholders. If that's the commission's pleasure, then I recommend closing the record. If the commission does have conversations with stakeholders as a result of commissioners reaching out after closing the record, when we return on the 8th, the record will need to be reopened and the commissioners will need to put those conversations on the record. I think by not closing the record today, the commission indicates that it is open to receiving unsolicited communications from parties. That does not obligate the a commissioner to accept that unsolicited communication or consider it or put it into the record. But by not closing the record, again, I think it's an indication that the parties, that the commission at least is willing to entertain unsolicited attempts to contact commissioners from parties. I would note that closing the record, if the commission moves to do so, that the motion should make a provision that that closing the record does not apply to that hearing officer order allowing parties to provide red lines and a one-page explanation of the red lines to Chairman Robbins' proposal on Rule 604 and ESPs.
Thank you for the summary. What are folks' thoughts on that? I know what mine are, but I'll let someone else go first. Commissioner Ackerman?
Thank you, Mr. Chair. My thoughts are the same as they were as we finished before with primary cases in chief. I think leaving the record open gives an opportunity to continue to receive input. I consider that input valuable. I have received some input between that time and now that I've found valuable as well. And so my recommendation would be to leave it open.
Others with thoughts? All right, I believe we're leaving the record open. And then I don't need to address the filing for next Wednesday since the record is open. I don't think there's anything further for us, commissioners. Good work. Take a well-deserved break. And we will
Mr. Chair.
adjourn. Go ahead.
Sorry, may I suggest a motion to continue this rulemaking until October 8th at 9 a.m. if I believe that's the correct date and time.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? We'll see you on October 8th at 9 a.m.